Present.
Commissioner Kimber,
Present.
Commissioner Mendoza,
Present.
Commissioner Caliendo,
Here.
Commissioner Vinacore,
Here.
Commissioner Rekener,
Here.
Commissioner Vaughn, Commissioner Kennedy,
Here.
Commissioner Williams.
Here.
Thank you.
Thank you. I'm sorry.
That's okay.
Lance.
We'll rise for the invocation and pledge.
Lord, we ask your guidance today as we consider matters that will affect the safety and welfare of many people in our county. Help us to listen with open minds to matters that are important before us and to act on those matters that will benefit those who reside in our area. Keep our minds open and alert, our hearts compassionate, and comments charitable. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Zoning Commission of Palm Beach County has convened at 9 a.m. in the Vista Center, Ken Rogers Hearing Room, BC 1W47, 2300 North Jog Road, West Palm Beach, Florida, to consider proposed applications and staff recommendations pursuant to the Palm Beach County Unified Land Development Code. The Commission takes final action regarding Class B conditional uses, subdivision variances, and Type 2 variances, and issues advisory recommendations on other requests. The Board of County Commissioners of Palm Beach County will conduct a public hearing at 301 North Olive Avenue, West Palm Beach, Florida, in the Jane M. Thompson Memorial Chambers, 6th floor, on applications not subject to Zoning Commission final notice. And continued. Zoning hearings are quasi-judicial in nature and must be conducted to afford all parties due process. The Board of County Commissioners has adopted procedures for conduct of quasi-judicial hearings to govern the conduct of such proceedings. The procedures include the following. Any communication with commissioners which occurs outside the public hearing must be fully disclosed at the hearing. Applicants and persons attending the hearing may question commissioners regarding their disclosures. Such questions shall be limited solely to the disclosures made at the hearing or the written communications made a part of the record at the hearing. Any person representing a group or organization must provide documentation that the person representing the group has the actual authority to do so regarding the matter before the commission. Any person who wishes to speak at the hearing will be sworn in and may be subject to cross-examination. The applicant and county staff may cross-examine witnesses. Any other persons attending the hearing may submit cross-examination questions, including follow-up questions, to the chair, who will conduct the examination. The scope of the cross-examination is limited to the facts alleged by the witness in relation to the application. Public comment is encouraged, and all relevant information should be presented to the Commission in order that a fair and appropriate decision can be made. Proof of publication?
Motion
Yes,
to
we
receive
have
and
it.
file.
Second.
All in favor?
Aye.
Aye.
Any opposed? Now we'll have the swearing in.
All those wishing to testify or speak on today's quasi-judicial items, please rise and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay, approval of the meetings from
Motion
previous.
to approve the minutes of March.
Second. Motion made and seconded. All in favor?
Aye.
Any opposed? None. Motion carries. Any amendments to the agenda?
We do have some amendments to the agenda, starting with B2 DOA 2024-01248 Cahigas Organization. The request of the amendment is to modify the development order amendment, specifically Exhibit C, relative to
landscape conditions for numbering and trailer. Item number 4, also landscape interior, renumbering. Item 3, ZCA 2024-1593 Nash Trail, modifying the development order amendment, specifically Exhibit C, engineering condition 2C, where we're adding it, and deleting engineering condition 5, renumbering item 6, ordering engineering number 6. Regular agenda B, 4, CA 2023-01791, Southland Water Resource, amending the Class A conditional use. Exhibit C, where we have deleted and added language to environmental condition 2, 8, and 11. We've also added to the staff report a letter from Richard Grosso.
And there's an additional letter at your seat that we received that we emailed last night.
Okay. Any requests to pull items from consent?
Mr. Chair, I don't need any items pulled, but just to, I don't see disclosures on the agenda. I think that usually is an agenda item, isn't it? So if we can add that to the agenda.
Yeah, that usually is.
And then I'll make a motion to approve.
Okay.
Yeah.
So historically, we've had disclosures for all items on the agenda at the beginning of the agenda. That is creating issues with us as we use this agenda and move forward to the Board of County Commissioners. You will see disclosures at the top of the consent item. We're going to do disclosures from now on at consent for the consent items, and then at the regular agendas, we'll do them at each regular agenda item. Okay, so it is there. It is the first item on the consent agenda is disclosures.
Okay.
We would like your disclosures when you do the regular items, when you do the regular items, just like the Board of County Commissioners.
Okay, that's great. That's
Very
great.
good.
Okay,
I make a
the
motion to adopt the agenda as amended.
Second.
All in favor?
Aye.
Aye.
Aye. Any opposed? No. Adopted. All right. And so we'll start with the consent agenda then.
Conflicts or recusals?
Are there any conflicts or recusals?
Oh, conflicts or recusals? Conflicts or recusals?
Okay. Any conflicts or recusals? We're starting on my right.
No.
I received a call from.
That's
conflict.
disclosure.
That's any conflicts.
No, I'm sorry. No disclosure.
Okay. No.
No, sir.
No.
I have none.
None.
No.
Okay. We're good to go then. Let's start with the consent agenda, then we'll ask for, at the top of the,
For
any
the
disclosure?
for the record, we'll just say that number 1, Z 2024-1751, the tax collector service is postponed to May 1st. No motion is necessary.
Okay, no motion needed on that one. Then we'll go to the consent agenda. Any disclosures, starting on my right?
No.
Yes, item 2, I spoke to Alejandro Bosch, and item 3, Aaron Lees.
None.
I have none.
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 All right.
We do have cards on item 2.
We do have some cards for item 2 on consent.
They do not wish to speak, but we just want to put them in for the record. And we have 3 cards for item C, and they are in support, but they didn't check whether they wish to speak or do not wish to speak. So I've got
Item 2 or 3?
3, yeah, on the consent. So Henry Handler, Gregory, I think it's Peton, and Aaron Lees. If you did want to speak or if you didn't, I just need to know. If you want to, you can come up. If not, we'll just put those into the record. Someone's coming up. Please state your name and address for the record, please.
Aaron Lees, 8465 101st Court, Vero Beach, Florida, 32967. And I'm here to speak about the Nash Trail Project number 3, consent item C2. So we are working through some conditions of approval. I'm representing WGI and our applicant for this project, and we are working through...
Excuse me, I'm sorry. You're the agent?
Yes.
Or you're the agent?
Yes.
You submitted a public comment card?
I submitted a yellow card.
You're not public. You're the agent. You're not
I
public.
apologize.
For the record, public comment cards we don't accept for the agent. The agent just gets to speak. So, you know, consider this applicant's presentation rather than public comment.
Okay.
Okay.
Okay, forgive me. I filled out the card they handed me. Okay, so I'm good to go?
Sure.
Okay. I just wanted to let the commissioners know that we are working through the conditions of approval, specifically land development condition number 2 with staff, and our intention is to have that condition finalized by the Board of County Commissioners hearing at the end of this month.
All right. Thank you.
All right. A motion on the consent agenda?
A motion to approve the consent agenda.
Second.
Motion and approved. All in favor?
Aye.
Aye. Any opposed? No. Motion passes. So now we'll continue with the regular agenda.
Item number 4, CA 2023-01791 is the Southland Water Resource. The request before the board is a Class A conditional use to allow a Type 3B excavation on 8,611.52 acres. The applicant will present, and then staff will do a presentation. But before our presentations, if you'd like to do disclosures now.
Yeah, any disclosures?
Chris Kammer, yes. I received an email from Cliff Hertz, who is a representative of the applicant, requesting a conversation. I had a Zoom meeting with him on Monday, in which he basically stated what the applicant is seeking here. Nothing that he stated affects my ability to remain impartial and render a decision based upon the evidence presented here.
Okay, any others?
Yes, I received a call from Carolina Villanueva, Florida Crystals, and she sent me I received an email with a letter from the water management, just information about the process, just to have more idea what is going to be discussed today.
Okay.
Thank you.
I spoke to Clifford Hurst on the phone, the applicant's representative.
I spoke to Carolina with Florida Crystals.
I spoke with staff in general about the proposal.
I received an email, but didn't for a conversation, but I did not speak directly with the applicant.
I received a call from Florida Crystals and had a brief conversation.
I received a text from Lisa Interlandi to say that she was going to be here today, but we didn't chat.
All right, let's start with the applicant's presentation.
Hello, for the record, I'm Cliff Hertz with Nelson Mullins Law Firm. I just wanted to thank you all for being here. We will have a PowerPoint presentation. Mr. Matt Eitzen, who is Vice President of Phillips & Jordan, which is the actual applicant, will be making that presentation. And, of course, we're always available to answer questions. We've brought a number of our team members here in an effort to make sure that whatever information or you needed or whatever questions you had would be answered. And I'm going to ask Matt to take it away.
I use this properly. Good morning, everyone. Like Cliff said, I'm Matt Edson, Vice President with Phillips & Jordan, and we're here to discuss the Southland Water Resource Project. If you want to go to the next slide.
Close to the mic.
Yeah, sorry. We're here to discuss the Southland Water Resource Project today. This is a project that Phillips & Jordan has been working on for nearly 2 years now. We're excited to present it to you and get you to understand more about the project. So starting in 2023, we first presented this project to the South Florida Water Management District Governing Board in October. That came after months and months of work with the district, our engineers, scientists, biologists, and others to provide a deep understanding of the project, where we were at, fatal flaw analysis, and making sure that the project works. A little history of Phillips and Jordan is we were the construction contractor for the A2 STA. We're now the contractor on the 10A intake canal for the EA reservoir. This project, we're going to show you a little bit about the location, but is just adjacent to both of those projects, which we've been on in the region. So a little bit about an STA. A stormwater treatment area, the A2 STA in particular, and this is not the first one of these we've done, and we've got several others coming along. Stormwater treatment areas are vegetative treatment to remove nutrients from the water coming south out of Lake Okeechobee and in other regions. There's several of these going in north of the lake as well, but STAs survive in a perfect range, in a perfect world, with 16 to 18 inches of water constantly flowing through there to keep them hydrated. And as that water flows through an STA and stays hydrated, the plants within the STA soak up those nutrients and retain those nutrients in the plant life. Now, when an STA goes dry, it's the most detrimental thing that could happen. So when an STA goes dry, those plants die, they decay and rot inside that STA. So when they become flooded again, that nutrients is released and it's flushed downstream. So you get these large charges of nutrients going downstream because there's nothing there to capture that material again. So hydration for an STA is vitally important, 12 months out of the year, 365 days, to make sure that these things function as they should and produce as much as they should for nutrient removal. So that's a little bit of technical background on an STA there to understand how we came to arrive at this project. So working with the district on A2 STA and being in that region, and working with the district on a multitude of other projects, I think we've been with them for almost 10 years now, we began to understand some issues that they were having with STA 56. And STA 56 is directly west of this project. So we'll get to that in just a second, and I'll show you the map. So as we moved into this STA project, like I said, Phillips and Jordan has been working with the district for quite some time. We're the design builder right now for almost 15,000 acres of storage and vegetative water treatment in the state of Florida. And the team that we selected for the Southland Water Resource Project has been charged with also delivering the A2 STA, has worked on some modeling for the 10A intake canal and the EA reservoir. That team was specifically selected for the Southland Water Resource Project because of our proximity to the project. We wanted to make sure that we didn't have any conflicts with the EA reservoir or the A2 STA, and make sure that we had the project in a region that would function for all of Everglades restoration projects south of our water storage facility. And I want to reiterate, this is a water resource facility, a water storage project. This is a reservoir. If you notice here, kind of give an idea of where we're at on the map, the C51 reservoir and the L8 canal is just west of where we are now. If you'll see on the bottom there, the A2 stormwater treatment area, which I just said Phillips and Jordan is wrapping up. I think we're turning that over this month. The EA reservoir to the east of the A2 stormwater treatment area. The Southland Water Resource Project is directly north. With the Miami Canal being conveyance, we make it available to STA 56 and A2 STA, which doesn't have a water source right now because the EA reservoir is not complete and likely won't be for upwards of 10 more years. So the project was developed with the understanding that the district could use an additional 50 to 60,000 acre feet of storage to make sure that STA 56 functions 12 months out of the year. Right now it's drying out in an average of 3 to 4 months a year. It's dying and recharging. And I actually think today STA 56 is dry for some pump issues and other water issues. So we developed this with the district and their request, and working with them and the state, we identified this specific region because of our knowledge of the geology working on A2 STA. The project functions because of the geology. The project functions because of where it's at on the Miami Canal. If it was south, it wouldn't be a benefit. Its benefit right now is because of where the location is. So to zoom in a little more, this is a celled approach to reservoir construction, which delivers the reservoir benefit much faster than that typical of an EAA reservoir. I think the EAA reservoir, the first memo was 2001 in that era. I think it's going to be delivered in 2035, I think is the date now. Our project delivers storage in under 5 years for the first 20,000 acre feet. So its beneficial use is much faster. So we're looking to deliver cells 1, 2, and 3, which is phase 1, 2, and 3, and under the first 5 years. And that gives us 20,000 acre feet of storage facility that's immediately being able to use for STA 5.6. Moving into that, this is a low hazard, shallow reservoir. We are not seeking any reservoir or any variances to go 15 feet below OWL. We're held at that 15 feet. Similar in construction to the A2 STA in height. So the Southland team has been working with Florida Department of Environmental Protection for almost 2 years now, providing early information to them in late 23, submittals in early 24, and they've continued to vet the project throughout the last year. It's critical to note that they've also sent us a letter, which you'll see in the future, that they have no apparent concerns with our project, and we are looking to move forward. The water storage facility, the reclamation of this facility and this excavation is the water storage facility. I want to make that clear. There's no way that we could be in compliance if we did not build the water storage facility. We purposely made the water storage facility the reclamation for the excavation. So no matter what, this isn't another mine, this isn't a quarry or a dry hole that we could walk away from. We have to build the reservoir with the levees, dams, roadways, cutoff walls, seepage canals, all of the above, to make sure that we stay in compliance to continue construction with the reservoir. This project will store and direct water to existing stormwater treatment areas, moving south out of Lake Okeechobee off the Miami Canal. The goal has always been for Everglades Restoration to continue to move water south out of Okeechobee and control discharges to the east and west. Those discharges, both east and west, feed red tide and cause other environmental issues, green algae, blue algae, and the above. And to mitigate that, the more water we take south and send through these STAs and send on to Florida Bay is the benefit to the environment. In combination with the EA reservoir, that's 240,000 acre feet at completion, we'll provide another 120,000 acre feet at completion, and that should satisfy the Florida Senate Bill 10 and the U.S. study, which called for 360,000 acre feet of storage south of Lake Okeechobee. For cross sections here, just so everybody understands, and I know it's hard to see on these larger screens, the Southland Water Resource Project is on the right-hand side of the screen. That is a low hazard reservoir. The bottom of our ending function is not going to go below the 15 feet below OWL, and it's shallow and only 4 feet of impoundment above ground. Our levees are similar in height to the A2 STA. If you'll notice on the left, the A2 reservoir is also excavated to a -6 because of the material it takes to build the embankment around the reservoir itself. And they impound water with a much higher reservoir. I think the top of their impoundment there is 44 feet. I think they retain about 29 feet of water. Comparison to the A2 STA. Again, Southland Reservoir is on the right. A2 STA is on the left. If you'll see the similar nature of the projects, we have the same seepage canals, same cutoff walls, and same level of levee height across the region. As far as environmental impacts for this project, the whole goal of the project is to provide the rest of the storage that the EA region needed, that has been asked for over decades now. And we have developed this project to deliver beneficial use much faster. The more water we can take south, as I said, is better for the region and better for both the East Coast and West Coast regions. For an economic impact, this project provides over 100 to 140 high-paying jobs, permanent positions, not temporary, for long-term employment in this region, a region that could really use the job market. Southland provides Palm Beach County with an average annual revenue of about $300,000 in aggregate tax payments, which is year over year. There's a tax on everything we send out the door, and that is paid to Palm Beach County every year. We've attached a copy of the South Florida Water Management District here. This was sent to us by Drew Bartlett, the executive director, and it was sent to be in accordance with Palm Beach County Comprehensive Plan. It also identified this specific site as a water resource project. That's very important as the next step for us to move forward. We also received our letter from the Florida Department of Environmental Protection pertaining to our application and the information that we provided to them, saying that there are no apparent concerns for our project. Currently, the next steps. Southland Water Resource Project complies with all Palm Beach County Everglades Agricultural Area Comprehensive Use Plan requirements. The project has been identified by South Florida Water Management District. The project's gone through an extensive vetting process through FDEP, and the project complies with Palm Beach County ULDC requirements. At this time, we would ask the board to continue forward with a staff recommendation of approval. That being said, Phillips and Jordan has a long history in this region for delivering projects year over year without fail. And in some instances, we've had to step in on other project failures and finish those and complete those projects. We are a water resource company. We're very in tune with the environment. The environment is very important to us, and those are projects we like to build. It's important that we continue these projects and we continue to work together with all stakeholders to move these projects forward to complete the mission of Everglades restoration. For that, thank you.
Thank you. Staff?
We have Iman Haddad here to present for the Zoning Division.
Good morning, Commissioners. For the record, this is Iman Haddad. I'll keep it brief today, but I'll situate us as far as the location of the project and what the requests are. So what we are before us is CA 2023-1791. The request, the site is located on the south side of an access easement approximately 1 mile south of Ocalenta Road, approximately 1.3 miles of Miami Canal Road. The roads are shown on the map before you. The site is located within the AP Future Land Use and the AP Zoning District, so the same designation. It is located on 8,611.52 acres, and the request is a Class A conditional use to allow a Type 3 excavation on the 8,611.52 acres. Before us is the zoning map locating the site within the zoning district and along close to the Miami Canal Road. The applicant provided a phasing plan and a site plan. The request, again, is to allow the excavation to generate water storage capacity and extracting materials consisting of sand, limestone, that will be processed and hauled via rail. The rail system within the site is shown on the site plans on the packet that was provided to you. The phasing plan indicates 13 subphases with an annual excavation rate of 276 acres over a period of 34 plans. The phasing plan on the phasing table is provided on the in the site staff report that was provided to you as well. Access to the site will be from the U.S. Highway 27. The access easement is shown on the phasing plan and the site plan. A detailed site plan of the facility was provided. It includes a 6,000 square feet main office, 7,500 square feet maintenance building, a 1,200 square foot laboratory, and a 16,000 square foot fueling station. There are a total of 30 parking spaces. Staff is recommending approval based on the conditions of approval in Exhibit C. During the review of this application, we received 3 calls from the public that were received from us, and we answered the questions and concerns that the public had. And then there are the letters with the communication in the staff report with the law firm that had questions and comments on the project. With that, I conclude my presentation. If you have questions for us, staff is available. Thank you.
Okay. We do have some cards and public wishing to speak.
We have a series of cards. I'm going to call two people up, so if one could go to one podium, one could go to the other. When you get up, you will have 3 minutes to speak. Please state your name and address for the record. So first up is Steve Wilson and Joe Kiles.
Good morning. Steve Wilson, the City of Belgrade Mayor, 110 MLK Boulevard, City of Belgrade. Mr. Chair, and to the board members and to all of you on your respectable place, I want to first say to you all, thank you for your commitment to the goodwill of mankind and allow me to come before you to speak on this important matter. I bring greetings to all of you on behalf of the City of Belgrade and all the elected officials that share the dais with me. I have with me today our city manager that has been in government for 62 years and been with the City of Belgrade for 25 years, Mr. Lomax Howard. I'm sure all of you know that I represent the city that was established some 100 years ago. And during that time, the creation of our state legislators created what we call a research station to monitor and survey the crops. And believe it or not, y'all, that research center is still up and going today. We're proud to let everybody know that they call us the Mutt City. Yes, we're the communities that help feed America. And it always seemed to amaze me, two things that we always should be mindful of in this country: supporting our veterans and supporting our farmers and our sugar industry. The Glades community is a part of Palm Beach County. Some folks don't seem to understand that. We have a saying in the Glades that says, don't talk with your mouth full. Honestly speaking, from the pictures I've seen on social media and the things that I've read and continue to read today, I'm left to wonder if the opposition will want to see us eat at all. I've been around a long time, 25 years in government, 20 years as the mayor. My question to all of our special interest groups: do you dislike or hate someone or something that bad that you're willing to take food off your own table or from your countrymen? It's very unfortunate that you good people that sit on the zone as commissioners must bear witness by some ideas on how to get rid of or how to destroy communities like mine, Belgrade, South Bay, and Pahokee. The data's there. We've been talking about this for years. Send the water south. Well, this plan, this project does that. Exactly what we've been talking about. I'm not getting it. If we've been talking about it and it's going to happen, why would we not support it? Thank you, Madam.
Thank you.
Thank you. Thank you.
Joe Kyle, you're coming up. And then next up would be Linda Smith.
Good morning, Mr. Chair, to the commission as well. Praises to you and your family. My name is Joe Cowles. I'm the mayor of the city of South Bay. We are the closest city of this Southland project, being about 7 to 8 miles north. I was employed at Okalanda Corporation for 20 solid years. I know precisely what it takes in reference to those individuals that live in that particular area, those individuals that live in that particular area, and those individuals that have worked in that particular area as well. I worked as a union representative for the International Association of Machinists and Aerospace Workers in Cape Canaveral, Florida. I worked at that particular facility for 40 years, but I was still intertwined with those individuals that worked in the sugar mill at Okalanda Corporation. An ongoing support of Everglade Restoration, and I have seen what the loss of farmland in the name of Everglade Restoration has done to my community and our regions of Palm Beach County over the decades. I have witnessed a change of faces and new names of organizations pop up in our area there, trying to, saying that they were named of the Everglades. We who live and represent the community, we continue to work hard in that particular community. We continue to make sure that those individuals in that community have jobs to be able to support their families. And they have made a great, great and wonderful living in those facilities, in that particular area as a whole. I am here to share with you that myself know the sugar companies as an intent in their public business, including priorities, their employee livelihood, and their family. This was my mission as a union representative, to make sure that those individuals had jobs, make sure that their families were well taken care of, make sure they was able to receive a prosperous wages for their families. And I've seen it over and over again. By me being connected a total of 40 years within the industry and also with the union as well. I'm here today to say to each and every one of you all, the sugar company and Phillip and Jordan are private industrials coming together to pursue a water storage project. To get to that, they're excavating their private owned land. Their excavation to meet market demand for agriculture will give cities like mine employees opportunity where my residents will be prioritized in local career. Learn on the jobs and make a good living to benefit their families. At this in the name of storage water, helping the Everglades. These 140 jobs are transformative for rural communities like mine. Yes, you know that we live in a rural community because due to the fact we're on the west side of the lake, along with the city of Belgrade and Pahokee, in the other outskirt of that particular community. I know my residents.
Thank you.
Thank you. Appreciate it.
Go ahead, Linda.
You may start.
Okay. Linda Smith, Sierra Club, Loxahatchee Group. We are urging you to deny this project at this time. This project is not a water resource project. It's a rock mine. A rose is a rose. A rock mine is a rock mine. Rock mining is not allowed in the EAA. How this can even be considered before South Florida Water Management District has completed its evaluation and comprehensive agreement is kind of a waste of your time and those that oppose or support. It will take South Florida Water Management approximately a year to complete their review. So let's see what they have to say. The South Florida Water Management and the Army Corps, I don't believe, have this on their project list for Everglades restoration. If it's a reservoir, I don't know. Don't sell the rock. Donate the funds from selling rock to other Everglades restoration projects, or maybe to roadway projects, which is the only place these rocks should go, or for agricultural activities. I'm concerned about where the water quality treatment component of this project is and how it's been evaluated. STAs are damaged when dried and also when flooded. It is a very complicated system. In November 2024, the Everglades Coalition, an alliance of 60 local, state, and national organizations dedicated to restoring the Everglades, outlined concerns that this project would set a harmful precedent, and this project was submitted to the Water District and then withdrawn. I mean, that was kind of a waste of time, too. I appreciate the staff's time, but I believe their suggestion to approve this at this time is premature. Wait for the district's approval, and we do support farmers to farm. Thank you for your time.
Thank you. Next, we have Anthony Julian and Lisa Interlandi.
Good morning, everybody. Thank you so much. I appreciate the opportunity to speak today in front of you on behalf of the fishing and boating industry, which I've been a part of for over 43 years living here in South Florida. My name is Anthony DeJulian. I made my living as a fisherman, as a consultant in the fishing industry for several years. I've spoken around the world on the fishing and boating industry, including in Jeddah, Saudi Arabia, and in Seoul, South Korea. I'm very concerned about this project. This project is a rock mine, is what it is. I've been involved in the fight for Everglades restoration for the last 10 years, and I've listened to all the lies, the gaslighting, the constant delays in fighting true Everglades restoration. So I'm concerned because this project could possibly jeopardize the integrity of the EAA reservoir and the overall efforts to restore the Everglades and sending the water south. This project could possibly erase decades of work for Everglades restoration and directly goes against the wishes of the citizens of South Florida. This project could possibly set precedent for further industrialization of the Everglades and all of our state and national parks. It could open the door for drilling and fracking for oil and gas and for further mines. And it could further threaten our drinking and bathing water and the boating, fishing, and tourism industries, which would be a disaster for our economy. Going along with this project would make Palm Beach County complicit in those lies, corruption, and criminality, and the destruction of our natural resources in the state of Florida. It's a bad look to approve a project that is yet to be approved by the South Florida Water Management District. At least I think you should wait until all of the information comes in before you would approve a project that has really not been vetted. In closing, I would just like to say I have nothing against any industry doing business in the state of Florida. However, this project is a rock mine. It has nothing to do with Everglades restoration or water going south. And I would urge you all to please vote no and not approve this project until all of the information has come in. Thank you so much for your time.
Thank you.
Hey, everyone. Lisa Interlandi. I'm with the Everglades Law Center. First of all, I want to thank you all for your service on this board and thank county staff for all the work that they've done. I know they've been under tremendous pressure to move this project forward, and sometimes with limited information that is coming only from the applicant. So I'm here today, and I hope that you guys can get some helpful information for your guys' consideration. So, first, why are so many environmental groups coming here to raise concerns about this project? We have the Sierra Club, Friends of the Everglades, Captains for Clean Water, the Everglades Foundation, and even the Everglades Coalition, which is a coalition of almost 60 environmental organizations dedicated to restoring the Everglades, have raised concerns about this project. Okay, that's because it has not been identified as a water resource project by the South Florida Water Management District. The applicant said that they made a presentation to the Water Management District in October 2023. They said that today. That was that the applicant came during general public comment and spoke for 3 minutes about their project. They did not give any presentation. There's been no discussion about this by any governing board at any governing board meeting that has been on the agenda. It's been discussed a few times at general public comment, but there's been not one public meeting about this project. In fact, this is the first public meeting that's ever been held about this project. It's not contained in any Everglades restoration documents. It's not part of the comprehensive Everglades restoration plan. It hasn't been identified by the Army Corps of Engineers or the Water Management District as any sort of restoration project at all. Now, are they considering it? Yes. In December of last year, they wrote a letter and said, hey, we've received your application, and it's possible that this could provide water resource benefits. That's basically what the letter said. It also said, we have now completed step 1 of our 7-step process that they're required to follow by law to evaluate whether this is a project that they're going to move forward with. They have a 7-step process. It's in 265-065 Florida statutes. It goes into extensive detail about the kind of analysis that they have to do. Okay, that analysis has not been done. They are just getting started. The South Florida Water Management District has told us time and time again that they are just now beginning to evaluate this project. The chair of the governing board was quoted in the paper saying, if this is a marathon, we haven't even shot the gun. Okay? This is not an identified water resource project by the Water Management District, and just realistically, that is what your plan requires. Your plan requires this project to have been identified by the South Florida Water Management District or the Army Corps of Engineers, and that just has not happened. So for that reason alone, I really want you guys to pause. Pause it and let them have the opportunity to review the project, reconsider it after it's done. It's so hard to consider and put all the conditions that you need for a project when there is so much uncertainty. When the project becomes certain, your job will become easy. It's virtually impossible to do it with all of this information that's not available. Okay, the other couple.
Thank you.
Is that it? My 3
That's
minutes?
it. That's your 3
Wow.
minutes.
Okay, thanks a lot, guys. I appreciate it.
Next, we have Gil Smart and Michael, looks like Zen or Zom.
Good morning, Commissioners. My name is Gil Smart. I'm Policy Director for Friends of the Everglades. We were founded in 1969 by Marjorie Stoneman Douglas. And while we're headquartered in Stewart, we have supporters across the region, including several thousand folks here in Palm Beach County. I'm here to express our concerns and objections to the Southland Rock Mine project. We do not believe the project, as it now stands, qualifies for approval under the terms of your comprehensive plan. Our attorney, Richard Grosso, sent a letter, which was a late addition to your packet, articulating some of our concerns. Specifically, we do not believe that this qualifies for approval under Comprehensive Plan Future Land Use Policy 2.3-E3, which strictly limits mining in the EAA to specified uses. The county's Future Land Use Policy allows mining in the agricultural production future land use designation, quote, only to support public roadway projects or agricultural activities or water management projects associated with ecosystem restoration, regional water supply, or flood protection on sites identified by the South Florida Water Management District or the U.S. Army Corps of Engineers where such uses provide viable alternative technologies for water management. This policy has been strictly interpreted by the 4th District Court of Appeals to preclude the approval of a mine that will be used for anything other than the 3 specified allowable uses, even when that mine will also be put to allowable uses. So any mine that will be used for any other purpose, for instance, general commercial sale of excavated material, is prohibited by your comprehensive plan. A mine that excavates materials for general commercial sales is prohibited, even if some of those sales are to be used for road building. The same is true of a mine that may be used for water ecosystem restoration, regional water supply, or flood protection in the future after it's used for general commercial extraction and sale, agricultural activity, or roadway projects. So there are 3 key questions related to the facts that must be determined before this application can be approved. Number 1, has the applicant submitted an executed contract with the Florida Department of Transportation where FDOT has agreed to purchase any specified amount of aggregate from the mine? Or is this all being done on spec? Is it being based on the applicant's statement that they expect to sell part of the aggregate to FDOT or another road building agency? Second, has the South Florida Water Management District executed a public-private partnership agreement with the applicant or made final determination that the mine will be used as a water resource project? As you just heard, the governing board has decided nothing. And third, if approved, would the applicant be able to operate the mine for general commercial sale of aggregate above and beyond any use for road building or water resource projects? For again, if any part of the excavated aggregate from this mine is to be used for general commercial sale, this applicant must be denied. The judicial interpretations of Future Land Use Policy 2.3E require the denial of this application if the mine will not be strictly limited exclusively to the 3 uses allowed in the policy. Approving it without that proof violates the county's comprehensive plan. Thank you.
Thank you.
Good morning. My name is Michael Zeff. I'm the president and CEO of the Chamber of Commerce of the Palm Beaches. We're located at 401 North Flagler Drive in West Palm Beach. This project was presented and thoroughly reviewed by both our Government Affairs Committee and our Board of Directors, both of which have endorsed this project. We believe this project will create local jobs and help to protect our natural resources, and we encourage your approval today. Thank you.
Thank you. Next, I have Valentina Mealy and Captain Chris Whitmore.
Hi, good morning. Valentina Miali with Florida Oceanographic Society. And today we're here opposing the Southland project. We are located in Hutchinson Island, so we are severely affected by Lake Okeechobee discharges. We are the first to support projects that store and treat water. However, today we feel that more information is needed before this project can be approved. More information is needed for South Florida Water Management District to vet this project and go through its review process. More information is needed to see how the hydrology will be affected, and how this will compromise existing restoration projects. For those reasons and the ones that my colleagues already mentioned, we ask you to not approve this project today. Thank you.
Thank you. Good.
Good morning, everybody. I'm Captain Chris Whitman, co-founder of Captains for Clean Water. We're an organization that focuses on advancing Everglades restoration for the benefit of our estuaries, our health of our waters, and our economy here in Florida. We would ask you to postpone the vote on this project. The applicant stated clearly that this is a reservoir project with beneficial use. It's clear, and to my understanding, that the South Florida Water Management District has not yet had time to analyze the project in order to determine if it is in fact a viable water resource project. Therefore, there is no way to tell at this point in time whether or not that is the case. That alone would be enough to delay this until the Water Management District has the opportunity to do thorough analysis to determine. And if at that point it does, then that's at the time that you would proceed with approving this project. The other is concerned, it's my understanding that this project is directly adjacent to the EAA reservoir. And this project and the construction of this project was not taken into account when the design and the development of the EAA reservoir project was taking place. It is my understanding there could be concerns of what impacts could the construction or operation of this project have on the EAA reservoir, the crown jewel of Everglades restoration. One of South Florida Water Management District's own board members, Ron Bergeron, who has extensive knowledge and expertise in mining, even raised concerns on the record that could this project possibly create unintended seepage or impact from that EAA reservoir. That's a multi-billion-dollar project that is underway, and it is critical to the health of Everglades restoration, the health of our waters, and it is important that we get this right, that we do not screw this up. I think that it was critical that you all take the time, let the Water Management District do analysis to determine if this is in fact a viable project. If it's being proposed as a water resource project, then it should be advanced and procured that way. If this is being proposed as an aggregate mine for road building, then it should be addressed that way. But it cannot be one or the other. Are we building a hotel or are we building a brothel? They're not one and the same. Thank you.
Thank you. I have one more card. It is Rufus Wakeman. Is there a Rufus Wakeman that wants to speak? Is saying that R-U-T-U-S?
His card is for the record.
Oh, did not wish. Thank you. I'm sorry. I had somebody that wanted to speak. I didn't read that. Thank you. That concludes the comment cards we have on that.
Any rebuttal from the applicant?
Yes, I'm going to ask Mr. Noah Valenstein, who's a consultant on the project and has extensive experience, former director of DEP, to come to the microphone to address some of the concerns that have been voiced by some of the opponents. On a personal note, I would say many of the comments were factually incorrect, and we're always happy to answer any questions that may have been, or any interest that may have been piqued by those comments and address them.
Thank you, Commissioners. For the record, my name is Noah Valenstein. I had the privilege of serving as the Secretary for the Florida Department of Environmental Protection for both Governors DeSantis and Governor Scott. Appreciate your time this morning, and again, appreciate the hard work of your staff doing a detailed review of this project and approval. I just wanted to reference, I know Matt mentioned the no concern statement from DEP and the ERP permitting process, and I just wanted to go into a little more detail on that. So this project requires a ERP, or environmental resource permit, that's issued by the State Department of Environmental Protection. In short, an environmental resource permit is required anytime there are alterations to landscape that could involve surface water flows, wetlands, or water quality. It's a detailed review. I think we've got the best team in the nation. I know you're excited and you have an amazing team yourself doing review, but I would say DEP's got the best team in the nation to do environmental reviews. And within that permit, they look at and require information such as 3D groundwater modeling, groundwater data, stormwater modeling, water quality data. They specifically required analysis as to whether it would affect works of the district, existing stormwater management systems, including the EA Reservoir Project and STA in Reservoir. They also specifically required an analysis as to whether it would impact water quality standards in the Everglades. I'll mention that that permit request requires the applicant to specifically deliver to the department the exact plans, construction standards, timing, phasing, some of the documents you saw this morning in order for them to issue a permit. And that permit would require them to build the plans they have submitted for a water resource project. Thank you.
Okay, thank you.
Rebuttal is complete.
All right, thank you. Commissioners?
I have a question, Mr. Chairman. Actually, I have of Lisa. Did staff not consider the South Florida management approvals in their process of recommending approval of this? And what's your actual thought about that in particular?
Okay, before I answer that question, this is somewhat of a unusual scenario. And this use that's before you is a Class A conditional use approval for a use that is allowed in the agricultural production zoning district and the agricultural production future land use designation. And the weight of the regulations for those are in the comprehensive plan. So in some instances, let's say the zoning district is commercial, the future land use designation is commercial, all of the regs are mostly in the ULDC, and your role as the zoning commission, you're reviewing the standards that we have for our different, in this particular instance, the use approval process, compared to the requirements of the county's land development regulations, the ULDC. In this instance, the weight of this request is largely in the comprehensive plan in that policy 2.3E that was mentioned by one of the speakers. That's why you may have noticed that the bulk of the staff report was drafted by Principal Planner Brian Davis here with the Planning Division, because that is the crux of this discussion and the analysis here. And I'd like to, for the audience, remind everyone that the action you would take today would not be to approve or deny. It would be a recommendation on approval or denial or such. It's a recommendation item for this board. So again, now that that's said, can you repeat your question, please?
Yes, I'm just kind of curious what the South Florida management process that would be required to really have them really proceed with this project. If there's that much of a chain of 7 requirements, what was the thought of the staff without them getting into that portion before coming to us?
And I'll turn that over to Brian Davis, and we also have Paul Linton, our water resource manager. Again, this is a complicated type of chicken and egg situation.
Do you want to start first, or? The short answer is yes, we did. In planning, we have a general understanding of the overall process. We do not have the technical understanding. One of the things we were looking for, given the very specific language in the plan, is there something available from South Florida? And we finally got that on December 31st. So yes, we did. We were looking for that. That was one of the reasons we withheld certification for a long time, is a lot of this was conceptual and there's a lot of moving parts. We did also look in other district documentation that's publicly available, did not readily see that, hey, this site, we can see some general things, but we're not exactly sure, because SERP, as we understand it, has been around for 25 years. There's been untold numbers of studies, thousands upon thousands of pages, different concepts, and as it's evolved. So we didn't would have loved to have found a really easy map saying, hey, we'd love to have something here. We didn't find that, but that was really not what we're looking for. We're looking for the applicant to bring it to us. So when we had that, we're saying this is enough, because the problem that you have in a comprehensive plan is it's very high level. It's not regulatory like a code. It doesn't say with a lot of detail what is the actual process for identification. It just said it needed to be identified. We look back at the old staff reports when that language was put in to understand the intent of it, some of the hearings that were before the board. It's not entirely clear what that is, but with something from the district says we're looking at it, there is a process. We also understand there's some unusual things involved when it's a potential project that will benefit the district, that the district is in a role where it cannot permit its own projects or projects that it benefits from. So that's why you're hearing from them about Florida DEP, about how they do their permitting process. We understand that the district may in the end be a beneficiary of this, but really it's going to be an FDEP thing. It's something that's not even entertained in the plan policy, and it's one of those things that the permitting is done, as we understand it, by FDEP rather than the Water Management District. So we have this sort of weird situation of a very old policy and a requirement there that we're trying to interpret in a modern sense with different practices now in play. And so we're trying to make it work. We actually, for the record, asked the applicant to go back and look at entertaining, updating, or asking the board to update the comprehensive plan to make it more clear, to maybe reflect modern circumstances. They elected not to do it, so here we are. This is the situation we're in. We have the best that we can get it to a public hearing to begin to have that discussion. The recommendation, as it's conditioned, we feel gives a certain reliance or ability to say this project cannot actually do anything ground disturbing until all of these things show up. But as Lisa said, there's a chicken and egg issue here of you really need the state permit, you really need the local improvement. Everyone wants the other side to go first. And at some point you have to advance something.
So are you saying that they're still going to need the state approvals, obviously?
Right.
But this can't go much further without somebody starting this thing and kicking it off. So that's why it's here with us.
I think it needs to go.
Yeah. Commissioner Kennedy?
So my question is this. I've read the report and the staff report and read all the documentation. There seems to be a lot of verbal reliance, like the applicant has verbally said, the applicant has made statement saying that they're going to use this aggregate for FDOT, that it's, they've titled it a water resource thing, but there's no written conditions of approval. My question to staff is, why weren't written conditions of approval created to require...
I'm sorry, have you read the exhibits with the planning conditions? Those are the most detailed conditions that this county has ever proposed on mining operations.
Requirement that it's for the public roadway projects or it's not the specific 2.3E
because they have made a representation that you have a water resources project. We are taking them at face value for what they are saying. However, there are representations that are made verbally in meetings. There are some indication in some of the application materials that we have from them that say that the aggregate could be for public roadway projects. If they wind up producing something that goes to FDEP, there is a reporting requirement in the monitoring conditions that require them to comply with that aspect. So it could go one way or the other. That's the problem we have. We don't have the permit in hand. We do not understand exactly what the intent is to do. We are trying to cover off either eventuality. So read the conditions.
But there's no preclusion that the aggregate gets sold for commercial uses.
I don't think it's allowed.
You can only, if you read the condition says you may only use it for the purposes enumerated in the plan. The condition specifically says such as if sold for public roadway projects. If they do not comply with the condition, we're back, we're sending the development order. That's where it is. That's the stop. The problem is we can't require them to do something and come ask us, can they do it? They're doing that now to get the general approval. The compliance will only be determined at the end. That's the problem you have with this level of regulation.
And so you're saying that if the South Florida Water Management District doesn't go through with their 7-step process, that there is no development order for them to go forward with this mining.
Timing mechanism is such that within a year, if they do not have it, they have an automatic check-in to the county commission with a recommendation that they revoke the development order. That's what the conditions require. So if the board at that point then wants to go the other way, there's some sort of mitigating circumstance, hey, there was a giant storm or whatever and everything was taken out for 6 months and there was no progress made, the board can consider that, but staff is going to bring it back under the conditions of approval with a recommendation that they rescind it. And so they will have another day in front of the county commission to consider the project and whether it goes forward or not.
Commissioner Ricker.
So if we approve this, what is the next steps for them? Well, I don't understand what their next steps are.
Well, if this board recommended approval and then it was approved by the Board of County Commissioners, the next steps for the applicant maybe should be answered by the applicant?
There's nothing that can occur on this site without a permit from the Department of Environmental Protection. Nothing can be dug, not 1 ounce of sand will not.
Speak up a little.
Not 1 ounce of sand or rock could come off this site or even
I get that.
be dug without an ERP permit from Department of Environmental Protection. That would be, you asked for the next step?
Yeah, but you have to go through the 7 steps and all these other things have to happen?
Well,
or are you skipping through that?
I can address that if you'd like.
Yeah, please.
And I may have better people here to do that. But my understanding, and do you want to, Matt? Yeah, I mean, there's this reference to the public-private partnership, but the condition would be that we would enter into a agreement with the district relating to the operation and maintenance. That's the requirement of the condition here. So this 8-step process is not the road that we necessarily have to travel.
Well, I would, but I mean, it's part of it from what I understand, because Tallahassee hasn't made the best decisions with the Everglades restoration over the years. Because that's why we're doing it, because of the things that they've done in the past.
So I'd say I think there are two things: whether the site was identified, and as far as next steps, council's right. The DEP would have to issue an environmental resource permit, right, which strictly reviews and conditions that project. I think the point about the public-private partnership that South Florida Water Management District is going through is that there could, in instances where Phillips and Jordan is lifting a large project like this, be different partners. You could have the South Florida Water Management District be interested in being a customer or partner and working through a set process for that. Like,
but are we skipping process, or are we going to go through the process?
I think this is the right process to move through. Right. So first, the county would go through to meet its comp plan. Right. Whether there's a site identified and whether you meet the comp plan, the ERP would have to be issued by DEP, and then the question would be, who's the partner? Is it a purely private project? Is it a project with South Florida Water Management District? The Department of Environmental Protection could decide that they like the project so much they want to fund it. The legislature or governor, any project within that could result in different partners, South Florida Water Management District being one of them.
I understand that, but that's not my question. Are we going to go through the proper process, or are we going to skip process because of partnerships?
I would say it's our representation that this is moving through the proper process.
That's not, okay. Thank you.
He's saying that they don't really know which way they're going to go.
Right. And it's the process that was laid out to us.
This is the
but I'm
first,
asking
this
for the
is the start
process
of the
that's
first.
going to be given if we give approval.
Any other questions?
Yeah, I have a question, I guess, either for the applicant or the staff. So the question really seems to be that, I mean, it's very complicated, the packet's huge, but it does come down to, as Ms. Amory stated, I think, policy 2.3E3. That seems like the crux of the matter here, which states within the agricultural production future land use designation, mining may be permitted only to support public roadway projects or agricultural activities, or water management projects associated with ecosystem restoration, regional water supply or flood protection on sites identified by the South Florida Water Management District or the U.S. Army Corps of Engineers where such uses provide viable alternative technologies or water management. And it seems like the appellate court for this district, the 4th District Court of Appeal, has strictly interpreted that and limited it. And the words mean what they mean. And so while ultimately this may be approved, this project, I think for purposes of this, for our recommendation, we have to abide by this provision. And I think the applicant has to show that this is a project that has been identified by SWIFMUD or the U.S. Army Corps of Engineers, and that the uses provide viable alternative technologies for water management. And I think what we've been provided shows that they're on the way, and that that may ultimately be approved by SWIFMUD, but they're not there yet. And what I see in the packets is a letter dated February 21st, 2025, from South Florida Water Management District to Mark Perry and Kelly Cox of the Everglades Coalition that states, "We will now turn our attention to thoroughly evaluating the project proposal. If staff concludes that it is a viable storage and treatment project that will provide regional benefits and that it will not impact the construction or operation of the EAA reservoir project, district staff will bring the project to the governing board for consideration before entering into a comprehensive agreement pursuant to Florida statute." And it goes on. So it just seems that this project may ultimately be approved by the South Florida Water Management District, but it apparently hasn't been yet, and that seems to be what we're required to look at, and we're likely, if we recommend this, going to face a legal challenge.
I think you hit the nail on the head right there. That is exactly it.
So I think we should make a recommendation.
Any other questions? Do we have a motion?
Well, maybe the applicant would like to respond, because those are what I've heard and what I read.
No, but I think that's pretty much what the board is trying to say as well.
It doesn't matter. We're going to I support you.
All right.
I mean, I guess what we've taken the position, and I think that staff has agreed, that the letter from the Water Management District dated December 31st, 2024 is in fact sufficient to meet the requirements of the comprehensive plan in terms of identification. As a matter of fact, the lead-in sentence to that letter says it's being done exactly for that purpose. So to come back and say, wait a minute, that's not good enough because they haven't approved a full project, that's not what the comprehensive plan says. What the comprehensive plan says very simply is there must be an identification of the site for that use. And we believe, and the staff has, I believe, agreed, that that letter is sufficient to trigger the process. And we're required to have an ERP permit, and there are other conditions of the permit that assure that this is a water resource project and will be a water resource project on an ongoing basis. So that's the only way I know how to respond to that. Ernie Cox, who has been involved in this project longer than almost anyone, also would like to say a word.
Good morning, everyone. Ernie Cox with Family Lands Remembered, environmental consultant on the project. As I think it was referenced, and actually referenced by Chauncey Goss, who's the chairman of the board of the South Florida Water Management District, the project has multiple approvals from multiple agencies that must be obtained in order for the project to go forward. And his comments at the governing board were, we've got a chicken or the egg here in terms of which goes forward. And a request was made at that governing board meeting to postpone, and the decision by the governing board was not to postpone, but to continue through the process. So part of the process is Palm Beach County review, recommendation from this body, consideration by the Board of County Commissioners, and we hope an approval by the Board of County Commissioners to go forward. There'll be additional testimony and evidence presented at that process. That's the county process. Noah Valenstein, former DEP secretary, talked about the DEP process. They're concurrent but separate with different rules and regulations. Over on the Water Management District side, Drew's letter concludes the first step of the process, which was the identification of the site, but then references there will be additional process if a comprehensive agreement is to be reached with the district, very similar to other projects that have been done with the district. You've got to go through each of those steps, and there's not one body that has authority over all of those steps. It's multiple. And so, as Brian mentioned, the staff has put together a detailed set of conditions that require us to meet each of those other processes, which we will be doing as we go through those. So this is the county process. I hope that's helpful.
Lisa, can I ask you a question, please? Do I understand staff, what we were just talking about a few minutes ago, if they do not meet these requirements in the time frame of making the application, say it's 12 months, whatever it may be, does that automatically come back to us and to you all, come back and rescind it? Our approvals are rescinded, and they have to start the process over again?
Those planning conditions were worked out with County Attorney Darren. You know, how that particular rescind process works, I'm not familiar with. In the time that I've been here, I haven't personally encountered a rescind condition of approval.
No, what I'm saying is it puts a timeline to what they're doing.
Brian, correct me if I'm wrong, the conditions are drafted that if they violate one of the conditions, we come back with a status report and to the Board of County Commissioners, and they can revoke the development order.
Right.
Commissioner.
Yes.
Well, I could provide some more detail on that if you would like.
If you want to go ahead, and then I'll make my
All right. Go ahead. Well, I'll run through this. There's 5 planning conditions that are effectively much more than belt and suspenders. Page 21 of your staff report, Planning 1, is that date certain, April 30th, 2026, we will have submitted to us a copy of the fully executed FDEP, Environmental Resources Permit, and it will demonstrate that the project is for the purpose of a water resources project consistent with the plan requirement for that. It then goes on to say if it has not received the state permit by that date, we will schedule a status report through the monitoring process to the board with a recommendation to revoke the development order. So they have that. The board will then have the opportunity at that point to consider. They can come in, present evidence. It will be a hearing. Everyone will, see it. There will be a chance for the board to weigh in and do something. So that's the first stop. Before they can do any ground, excavation, they must provide the permit documentation to us. That does not have a timing, but the idea is you can't do anything without this in hand. So there had been some concerns internally that they could somehow, with just our approval, run out and go do something. No, you have to have the other side of the permit. That's the second part. 3 is the actual monitoring requirement. It somewhat echoes what's already in the code, but it also has the more specific. This is where the FDOT public roadway side comes in, is if for some reason they decide to engage and sell that, they have to demonstrate that not only did it go for a public roadway project, it was sold to a contractor. The contractor has to then also provide a receipt that said they did receive it and it was indeed used. It's the best assurance we can have. If it never gets used for a public roadway project, then they don't comply with the plan. Right. So that's the idea. You have to do that. There will probably inevitably be something for the purposes of mining beyond what they need to build the embankments and whatnot for the enclosure and impoundment. That will probably also, they have considerable areas on their site plan indicated for where they will lay down other aggregate or whatever that will never go off site. So we understand that could be that so-called ag purpose. But the idea behind the next 2 is they will then give us a phasing, at the end of each phase, they will say all of this, they will have to provide the conference agreement or whatever they come up with the district or the other governmental entity who will take this on. They will have to comply. They will have to show. So we will get this check-in regularly. Not only will we get an annual report as to where they are that year at the end of completion of each phase, which is about every 3 or so years, we will get another step. And so this is a very long project. And then the idea is if the final one is if they are, for any reason, have their permit revoked, they have a certain time to cure and to either get it or they have to come back and it gets extinguished. So we have tried to come up with the most exhaustive covering of every avenue. This effectively could get a development order. It's very common in the span of development orders and how they work in this county is you're getting what you get from the county commission in the end is a development order that has conditions before you can actually execute that development order, which is down the road. So things like platting, roadway improvements, payments for, whatever you need to do to get that. It's not all there the second you get the development order from the board. It's to do this, to actually use it. This is the same process. It's just not as familiar, say, a PUD or a commercial plaza or, a place of worship, the normal stuff that you see. So we've tried to take this and make it a familiar, but provide that assurance to the county, to the public, that this will have regular check-ins, because this is a very unusual project. We understand from a land use perspective, a mining or excavation or whatever is effectively the last use of the land. The land isn't there anymore, so we take it very seriously. That's why there's a lot of consideration.
Plenty of check and balances in place.
Right, so that's what we're trying to do. Okay. And so that's why look, the conditions, we think if you read through them, make it very clear that this really doesn't go anywhere beyond just a paper approval.
Right.
They have to ultimately produce.
Commissioner Vinegar.
Yes, this is extremely technical and very detailed project, very scientific, very interesting. And we've heard this chicken and egg from several people, and that's probably because the South Florida Water Management District Board Chairman Goss called the approval process, like between the county and the district, like a chicken and an egg. He said you can't have one without the other. And in reading the transcript from the South Florida Water Management District, Executive Director Drew Bartlett clearly stated on February 14th that the Palm Beach County is looking at it from a land use lens. But the South Florida Water Management District is looking at it purely from a water management lens. So I think we should look at this through our zoning and land use lens, and I think I'd like to make a motion to approve 4A, to recommend approval of item 4A.
We have a second?
I'll second that.
Seconded by Commissioner Pavlik. All in favor?
Aye.
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 Any opposed?
I would say nay.
Nay.
Can we have the names for the record, because it's going to be really hard for us to write that down.
Yeah, hold on. I think for this one, maybe a roll call would be better. Just go
Okay,
down the line.
let's do a roll call. Starting to my
Well,
right.
can I ask a question
Okay,
before we
one
do,
more
before
question.
we do this? I'm concerned. I'm just concerned because why hasn't more been done before it got to us? Like, why are we the starting point here? Why are we the kickoff for things, more of this to have been done?
Start somewhere.
But why at us? This is a bigger project
We're
than
the
us.
least on the totem pole, I think. I hate to say it that way. We're the least of the cog in the totem pole.
Yeah, the challenge before this board is, do you believe that there is the competent substantial evidence to support the staff recommendation of approval? And if you disagree, you recommend denial. If you agree that we've provided the documentation and evidence that you need with the material from the applicant, considering the testimony that's verbal and written that you've received today, you just,
Because typically we get more. We're further down the road before we see it.
Yeah, but
right?
we got,
This is an
we got
unusual-
numerous checked and balanced in place, otherwise I wouldn't be for it either.
So can I add
Okay,
one?
yes, one more comment.
in response to that, and I agree with that, because it seems to me that there are requirements that need to be in place before we would approve. Like, there needs to be a South Florida Water Management District project before we approve rock excavation in the EAA. That is something that's in our comprehensive plan, that there needs to be a designated project. There is no, so that is a requirement, I see it, before we make an approval. There is not a requirement at South Florida Water Management District that the land development be approved first. There is no requirement in the South Florida Water Management District permitting and approval process and CERT project that this land be zoned and approved with a development order for mining. So there is They don't need a prerequisite. We need a prerequisite. And for that reason, I would say no.
We're not approving mining. We're not, that's what
We
I think
are.
Lisa's
This is a
saying.
mine. It would be a mine and reclamation project.
This
how
is
it's been
approval of
presented.
the Class A conditional use request is for a Type 3 excavation.
Okay.
That is, if you're approving this today, you are approving the excavation.
Yeah.
But they can't do the excavation without getting all the other stops.
True.
That's my point.
Right.
There's all
There is a
this-
prerequisite before they move forward with the county part of it, but there's not a
You just got through
prerequisite.
explaining what stops are in place. If they don't get it, it comes back to us and it's done.
That's,
Okay, we have a motion, we have a second, we're going to do a roll call, starting to my left.
Chris Kammer, I recommend deny.
Sorry, the motion is to approve, so you would be voting no.
No, then.
It's only no that I can have to ask?
Yes or
Only
no?
yes or no? Not,
Yes or no.
Not any comment. Oh, my God. And I would say yes, because they have to come back.
Yeah.
Yes.
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 no.
No.
All right, that is it. It has passed as a recommendation to the county commission.
5-3.
We have.
And now, you have more comments? Sorry.
No, I just for the record, after we had approved the consent agenda, we did get 2 comment cards. So just for the record, on consent agenda item number 3, just for the record to put them in there. So we-
Motion,
Yep.
motion for an
Motion to adjourn? Second?
Second? All in favor?
Aye.
Aye. And opposed? No. We're adjourned.